The Honorable, the Supreme Court.
And good afternoon, everybody. Thank you very much. Please be seated.
Good afternoon, Your Honors. The matter before the court this afternoon is the case entitled In Re State Airport Hangar Lease Disputes, case number 23 AP 336. Appellant Scott Winnick, self-represented. Representing the appellee, Vermont Agency of Transportation, is Jeff Sokolic.
Okay, thank you and good afternoon. Mr. Winnick, come on up if you would, please. You a lawyer? Do you know the process or? Huh?
No, I'm pro se, so this is, this is my first rodeo.
This is your first rodeo. All right. Well, welcome. We're glad to have you here. You understand you've got 15 minutes and the light will go on. We're going to give you some advance warning when your time is about to expire. So please go ahead.
Thank you very much. Good afternoon, Your Honors. My name is Scott Winnick, and I represent a group of 12 hangar owners from two different airports, Northeast Kingdom International Airport in Newport, Vermont, and the Stowe-Morrisville Airport in Morrisville. Today, I'd like to briefly address the Transportation Board's split decision regarding the rate increase on our leases for the land underneath our hangars that took place in July of 2019. And it was a rate increase that was determined by the Agency of Transportation. I'd like to take just a moment to highlight the key points of this appeal. We're here today primarily because in their review of the record, the Transportation Board overlooked critical admissions by the Agency of Transportation, which is that the rate increases were simply not determined.
I understand you're not used to arguing here, but there are things that seem to be missing from this case. So you use the word record. What is the record? The record, as near as it seems to come here, is what there's before, and some pre-filed testimony of one official of Agency of Transportation, but we don't know anything about internally why they reached a decision, do we?
The record is for the Transportation Board was both two things: the administrative record provided by the state, which is.
What did the state provide? That's what I'm trying to understand.
They provided 2.5 feet tall of records that were the correspondence, the leases, all of the correspondence between not only me, but all the other hangar owners. Some of them are here today, that's why I'm pointing that way. And that took place between the Agency of Transportation and the hangar owners. 99% of it was irrelevant, as may be the case most of the time. But
so I'm back on why did they choose this level of increase? The board seemed to understand that the issue was, could you go back and consider of the three factors that are in the leases, that two of them had not been used to update the leases rents over time. And so they went back to trying to do it since the last time they were updated, well over the lease limit. You argue that you can't do that. The state argues that we can. Is that the only question for us, whether the contract allows them to do it in that way?
well, I think the contract itself includes what's called the general terms and conditions that are included as part of all of our leases. And in that general terms and conditions, it specifies that every time that the hangar ownership changes hands or it's passed in some way that the lease is renegotiated, that constitutes an opportunity for the state to revise the lease rate. And it's not an unreasonable assumption for those of us that have hangars there that when you obtain that lease and you've had the opportunity to get it from the state, renegotiate anything, which is very little that you can discuss with them, you accept the lease as it is essentially. They've had a chance then to adjust the rate to the proper values. And you're starting with an investment in a hangar on top of this land that has that justification as your basis. When less than 2 years from that time, the state comes back and says, oh, by the way, we hadn't made any changes to the lease rate for time immemorial, maybe 6 years, maybe 7 years, not the 2 years that I owned the hangar, that they can stretch that rubber band all the way back to that point in time. It's arbitrary as to how far that can go. And all of a sudden, your rate increase comes from 1980 to 2020.
Isn't it just 2 to 5 years?
Excuse me.
Isn't it just 2 to 5 years look back? It's not infinite. Period of time.
It's indeterminate to me. The state, in our case, simply said, we're going to reach back till the last time we did this on some aspects of the three criteria. Three criteria being the fair market value of the land underneath the hangar, the expenses for maintaining that particular airport, excluding capital expenses, which are largely federal expenses anyway, and the third criteria would be the consumer price index, which is really well determined and easily tracked.
Okay, so how did they get up from 16 cents a square foot to 25 cents a square foot when they changed the lease terms? Any idea where?
How did they do that?
Yeah.
It's a great question. That's a question that we asked from the very beginning of this entire process to try and rationalize how that took place. And the explanation that we got, and probably the best explanation that we got, was a meeting that took place on December 10th of 2020, which is considerably after the increase happened.
This meeting is not the court proceeding. And there's no record of it, I take it, to come in. There are some disputes about what was actually said in this meeting. And really isn't something that we can go back to and say, gee, this is where information was provided. Is it?
Well, you started off when you were speaking to me saying that you understand I'm not an attorney, I may not understand how the process works. But I would have thought that at this point, you would have had access to all those administrative records and any references that were made in our brief that referred to those, that they didn't need to be provided in addition at this time to the Supreme Court. So we didn't do that. We made all our references back to the filings that were made, both the printed case and the administrative record from the Transportation Board hearing. And there were a few additional materials that were the enhanced printed case of any material. I did submit those, of course, when we began this process for the Supreme Court.
But is the meeting you're speaking of the one where Ms. Broussard testified or spoke or whatever
Exactly.
it was she did?
Yes, it is.
All right, and there was a recording of that at one time, apparently,
Yes, there was.
and that's lost?
Glitched.
Glitched.
What does that mean?
Is that different than lost?
It seems to put the blame elsewhere. Lost, usually you lose it. Glitched just happens.
Its present whereabouts are unknown.
Correct.
Okay.
Now,
What about its,
I'm using
what
the.
about its content?
I'm sorry.
What about its content? Are we to rely on the notes that you and your friends took as being what was said?
They were submitted, yes, is the short answer. And immediately following that meeting, we circulated contemporaneous notes that we took with an opportunity for all of us. Two of us are in the room, myself and Mr. Galvin, who's back over here. The third party is Dr. Sims, who was also on that call. None of the other folks that are in this room were on that call. But the point of that recording was so that they could have heard what was said at that explanation, if you will. So yes, I am asking that that information was submitted. It was always part of our discussion, certainly part of our briefs to the Transportation Board. It's certainly part of our record now. And there's never been any pushback on that, what was said, ever, whatsoever in that regard.
you seem though that again, the perspective of trying to figure out what the question is, at least that I'm going through, is you seem to suggest, and there are references that might lead you in that direction, that in fact, these are the two factors, that is the value of the land and what investments have been made in the airport, weren't actually used. They were, in fact, it is true that those things weren't updated as more investments were made and the value of the land increased. What really happened is that they went and got some figures about what was being charged in airports outside of Vermont. And they use those to make the determination from it. It isn't one of the three factors, but it's what actually happened. And you don't like it because the airports aren't similar to the airports that are involved here, you think. Is that something we're supposed to decide? What is that? What is all of that about the truth? Is your position that you can't go do this? That is from the Agency of Transportation. How do we deal with that?
Well, Your Honor, I think the creative license to compare airports like Hanscom Air Force Base and Albany, New York, to airports like the Northeast Kingdom in Vermont and Island Pond, the license to take that kind of an expanded view and compare rates across that kind of a spectrum is well beyond anything that's reasonable. So I am proposing that that's out of bounds, if you will.
Both the airports that are involved are uncontrolled, correct?
Sorry?
Both of these are uncontrolled airspaces?
Virtually all of them. I'm trying to think if there's a tower. The only tower that I'm aware of in Vermont is at Burlington, and that's a city-owned airport. That's not a state-owned airport. So that's not part of this discussion. Most of them are uncontrolled class
And
D or
so when
C.
you're looking at the rate of increase, there were some safety advances that were made at both fields, or the fields that are part of this,
Sure.
with taxiways
Sure.
and extending the runways on both, which benefits certainly the pilots who utilize those facilities. And so shouldn't that be factored in as part of an additional cost?
It should be. I agree. There's no pilot that you speak to in Vermont is ever going to contest the fact that rates will change. The part that we're contesting is that rates more than doubled, 160% in one case that I'm aware of the four of us at Newport, and generally 100 and some percent to everybody else across the state in one fell swoop. That's the part we're objecting to. No reasonable Vermonter is going to question that the cost of running these airports, running the airports, goes up over time, not the capital expenses like the taxiways that you mentioned or the length of the runway improvements. Those are mostly, I'll say mostly, federal expenses that come with other strings attached. But yeah, no, I don't think there's any objection.
Federal government saying, we're putting in money here, we want the other sources of revenue to be up to date.
Correct.
So the fact that came in by federal money isn't for these improvements. Doesn't mean that you shouldn't be increasing the amount you're paying too.
That's correct. But in the Federal Aviation's own circular that covers this information, they make very wide allowance for the small rural private airport, publicly owned airports in states like Vermont to set rates that are not trying to recover all of those expenses on the backs of the few pilots that are private aircraft owners for the most part, not commercial enterprises. They give a great deal of leeway. And of course, that information was part of the administrative record that we submitted as,
Mr. Winnick, this is an administrative body, and this court gives great weight to administrative boards, particularly in their areas of expertise. So the fairness of rents and fees would be within the expertise of the transportation board. So why should they not look to the costs at other airports to make a determination as to rate increase?
well, the transportation board didn't do that. It was the Agency of Transportation that went far afield and looked at it. There's no reason that they shouldn't do that, but they must do it in a commensurate fashion that gives a solid business explanation and a solid foundation for people who are going to invest hundreds of thousands of dollars to build hangars at these state airports. When people spend that kind of money, they expect a stable environment. You can't have the rubber band snapped like it has been in this particular case. And that's the reason we're here today. It really is a matter of degree, not a matter of if.
And Mr. Winnick, it's not required that you have a hangar. You could leave the plane outside. You could leave it outside if you wish. You might not be able to use it as much in the winter, but.
Correct. There are tie downs available
Okay.
outside that are, there's a fee for that. You pay to it's called the FBO, the fixed base operator. It maintains a certain number of tie downs outside that are mostly for transients. They don't like long-term ones for the winter reason. It's too hard to plow the ramps and things if there are lots of planes outside in the winter. So generally, the FBO operators, we happen to have them here today if you have any questions for them. Yeah, that's true. You can leave a plane outside. Not good for the plane, not good for the airport, but you can do it. Yeah,
Maybe not good for the pilot in the wintertime.
yeah, yeah.
You said in your rebuttal brief that the public process defense is a distraction. What'd you mean by that?
Who said that?
You said in your rebuttal brief, that's what I've got a note of. The public process defense, you said, is a distraction. No? Ring a bell?
No.
Okay. Leave it alone.
Public process. Oh, perhaps I was talking about the VAC and the committee meetings that took place at the VAC to try and establish whether this had any merit whatsoever.
Yeah.
With regard to the VAC, it does ring a bell. The VAC is a Vermont. Are you familiar with the VAC across your honors?
No.
It's the Vermont Aeronautical Advisory Council. It's
Oh,
a
yeah.
council of people
Right.
that are hand-selected, very homogeneous in their viewpoints. They're used by the board and by other agencies as a sounding board for some of these things. They have no administrative authority. They have no right to pass, rate increases or anything like that. But the VAC was used as quite a justification for moving forward with this. And I think the comment that you're referring to is
what
most
that's
likely
about.
from that. So I
Okay.
apologize for.
No, that's all right. Your light is on, so your time has expired, Mr. Winnick. Thank you very much.
I appreciate your time today and all of the people involved with Vermont aviation across the state who take an interest in this case. And I assure you there's many of them. Thank you for this opportunity to present our case as well.
Thank you, sir. Thank you. Please resume your seat and we'll hear from counsel for the appellee. Please come on up to the podium. And if you would, for the record, introduce yourself and identify your client before you proceed.
Thank you, Mr. Chief Justice. Good afternoon, Your Honors. My name is Jeff Sikolik. I'm representing the Agency of Transportation, the appellee in this case.
Thank you.
I'm here today to address why Vermont Transportation Board correctly affirmed AOT's 2019 adjustment of the ground lease rates for airplane hangars at two state-owned airports, Northeast Kingdom International Airport and the Morrisville Stowe State Airport.
Can I go back to the record, because I'm still concerned about whether the record is adequate. Do I understand the only thing that was filed by the agency was this pretrial testimony and essentially the letters that were sent to the various hangar owners giving the new rate legal for them? Is that what I understand was the record?
Not limited to that, Your Honor. The AOT also submitted, as part of the record, emails establishing the fact that we had shared this data and had communications with the appellants. That includes that AOT consulted an independent appraiser.
After you sent them the letter making the decision on what the rate rental level would be.
That is correct. So the public process, I don't mean to jump around here too much, but the VAAC meetings are very important and crucial to understanding this process in regards to fairness, which is an issue that appellants seem to raise. Over more than an 18-month period, AOT actively engaged with stakeholders through the Aviation Advisory Council.
Explain to me the criticism that came from the board that said that they were disappointed with the degree of explanation of how the factors that are in the leases are related to the result of the rent increases. And then they went on, of course, to talk about whether you could consider cost increases on a curve outside the lease. But that criticism seemed to indicate that they didn't think they were getting an adequate explanation for how the decision was made.
I understand, Your Honor. I believe my understanding of what the T-Board took issue with the less than ideal written articulation of AOT's method in the administrative record. However, I believe this had more to do with practical preference for meetings, individual, in-person, or Zoom meetings with with stakeholders, including appellants, presentations before the VAAC, and phone calls in lieu of written decrees as this process was taking place. But in tandem with those less formal communications, we also supplied extensive records. They can be found on supplemental printed case, pages 96 through 104, includes the whole list of data that we communicated to appellants on multiple occasions and the VAAC that this is the data of comparable airports. We looked at their rates and their similar offerings and maintenance obligations and compared those and established a market rate through that process. Pages 105 through 110 also include an independent appraiser who we hired to look at the market value of the airport.
If I could just interrupt you, over a period of years, let's say 4 or 5 years, how often did you engage in the process you've just described?
So part of the reason that I think that the appellants take issue with is that the most recent adjustment before the 2019 adjustment happened in 2008. Because during that period, from 2008 to 2019, we did make regular interval adjustments at the end of each appellant's lease period. And those were
Pro forma type adjustments.
Correct.
Without engaging in the process you described.
Correct. We do have obligations, rent assurances from FAA for the federal money that we receive to keep these airports as self-sustaining as possible. This is a strict requirement. We receive pressure from FAA to do this.
I'm sorry to interrupt you again, but the appellant attached, and I don't know how current, it's not current, some of the Federal Register from 1995, notice, as you may remember this in their brief, whether perhaps you could comment on whether this is applicable, but it says under 2.3 that in the absence of an agreement, allowable costs in the rate base are limited to operating and maintenance expenses. So is that something that was applicable here? Did you regard it as something that would control what your rate adjustment was that took place annually?
Ultimately, we feel that the lease agreements are what control our actual obligations. The language that I used explaining the FAA's requirements of us, that this airports be self-sustaining as possible, is about as tight as the guidance goes. Okay. So there is interpretation that we need to take place, need to engage in, and the agency has been managing these airports in regards to any deference that might be owed. We've been managing these airports for the better part of a decade, and this is the exact same process that took place in 2008 when these rates were last adjusted, and there were no.
So can we talk about deference for just a second on how are we supposed to give deference when the amount of information is not necessarily easily available for us to review?
Well, that is probably in part what the Transportation Board took some issue with. How to connect those dots was not specifically written out and articulated, but it was discussed and shown through the data. It is rather straightforward looking at the numbers, how we landed at 24 cents or 26 cents per square foot, which is still on the lower end of all state airports, just in the state of Vermont, not even looking regionally. Any appraiser in a specialized field will tell you that the process of establishing market value is just as much an art as it is a science.
So why wasn't if that's the process we went through, why wasn't the analysis of the data that came from the other airports and the appraisers' opinion offered in evidence to the Transportation Board said they never got anything, either of those. And while it appeared that some of that was part of what was going on, they never saw it.
It was in the record, Your Honor. However, it may have been, as appellants highlighted, it was a voluminous record and perhaps could have been better organized chronologically. So I think it just was difficult to navigate. But there was both the same pieces that are included in the supplemental printed case, pages 104 to 110 and 96 to 104, were part of the lower case. And that is the raw data that was used in making this calculation. In regards
to the missing thing that we made a decision based upon the increases in the two factors of to the price of things. And here's how much we got as increased value, how much it costs in terms of maintenance and what we've done to do. And we got an appraiser to do this thing. And when you do the math, you come out with this figure. That kind of analysis was clearly not there, right?
That's right, Your Honor, but the doing the math, the hard algebraic formula is something that is just, there's just no way to do what they're asking us to do. If we were to actually take the raw costs of operating and divide them by the number of renters at these airports, these costs would be much higher than what they're being asked to pay. I think we did include a note here that, you know, based on information provided by appellants from Morrisville Hangar Association, the average rent for the association's members with the disputed AOT's rate increases included is $58.75 per month for the exclusive use of a private airplane hangar. So how we land 1 cent higher or lower is difficult to articulate. As I said, this is just as much an art as a science. We're doing comparable maths here, balancing FAA's requirements and also the state's requirements that we make these airports desirable, increasing aviation use throughout the state.
We can't just take a dart and throw it at and say, this is going to be the amount that it is. It doesn't have to be based on something quantifiable.
Well, it is, Your Honor, the data that's provided, if you look at the rates and square footage rates that are included in there, there are clusters, some that are much higher, and these are much more advanced airports with more offerings. And then there's other airports that are in the, you know, the range of 20 cents per square foot to 30 cents per square foot that are very similar. And while there might have been better articulation to support that, we feel that these are reasonable, and ultimately the lease does not require us to provide a completely documented formula when making these adjustments. It just asks that they reflect the current market value and maintenance costs at the airport. And this is the determination based on the experience of those at the agency, how they felt it best fit.
And you used, I'm sorry for interrupting you, Mr. Solodek, but you used the same factors in every lease recalculation or adjustment, correct?
That is correct.
Same fact. And the lease term was, for all the renters, was pretty much identical. The language, with the exception of, I guess, the factors that would, taking into account, I'm sorry, the time periods for the lease renewal and the CPIU look back, correct? Those are really, that's the only thing that was different with every lease, but otherwise the language is exactly the same.
That's correct. That's uniform across the state, Your Honor. In regards to fairness, which I believe is an important part here, the airport hangar lease rate increases were fair. The terms were negotiated at arm's length, and what the leaseholders had sufficient opportunity to understand the terms. At least one of the appellants had legal counsel at the time the leases were negotiated. The appellants cite a 1993 case, KPC versus Book Press. This court, ruling on a claim of unconscionability and dispute over fairness over rents, upheld similar lease terms where the parties were sophisticated, the provisions were clear, with an emphasis on clarity. And I think it is, there is no dispute over the lease language, and it really doesn't seem, the plainest reading of this statute, there's no way to read the contract language that can construe that 2-year time constriction to apply to the latter two factors, market value and maintenance costs, and no other time restriction is present. Only the requirement that the adjustments reflect the current state of those other two factors, which the agency felt that it did, to the best of its ability. If your honors have no other additional questions, I would just say that the agency, as I stated, utilizing its expertise in managing the state airport system, which it's done for over 50 years at this point, made these adjustments based on the clear lease language, thorough methodology, and careful consideration of all relevant factors. For those reasons, we would respectfully request this court affirm the board's decision. Thank you very much.
Thank you very much. Does the appellant have any time left?
The appellant does not have any time.
All right, call the conclusion of the hearing, please.